But at this time, I'd like to move forward and introduce to you our moderator for the webinar, Mr. Tim Gagline. He's a good friend, and he will lead us today through this webinar and dialogue with our presenter. Tim currently serves as the Vice President of External Relations for Focus on the Family, and he previously served in the George W. Bush administration as the Deputy Director of the White House of Public Liaison, and he was a Special Assistant to President Bush. Tim grew up in Fort Wayne, Indiana, and now lives in the D.C. area, and he probably knows more about what's going on in Washington than just about anyone. He's a member of an LCMS congregation in Alexandria, Virginia there, and we're just very grateful to have Tim on the line today to moderate our webinar. Thanks, Tim, and if you'd please proceed.
Thank you, Barb, and good morning to everybody from a very snowy Washington. You mentioned that I was born in Fort Wayne. By complete coincidence, I had to be there on business on Monday for a speech in behalf of Focus on the Family, and that giant snowstorm that seemed to begin in Fort Wayne and sweep across to the eastern seaboard and out to the Atlantic Ocean left me, may I say, partially happily stranded in the Midwest. I was able to get back last evening. I was very sorry for the first time in 25 years not to be a part of the March for Life. I know my friend and colleague Matt Bowman, who is here, did participate. But good morning to everybody from Washington, and it is a real honor and pleasure in behalf of Focus on the Family to moderate this first webinar. And we are speaking this morning in our very first gathering of this new year on perhaps the issue that is the greatest threat to the religious liberty and rights of conscience of those of us who are followers of Jesus Christ. We at Focus on the Family have tracked very closely the cases in the Supreme Court, which we are going to discuss this morning. In fact, by God's grace, our office is just across the street from the Supreme Court, and we have followed at Focus this issue closely. We work very closely with the Lutheran Church Missouri Synod, of which I'm very proud and pleased to be a member. And I thought it would be very important to invite Matt Bowman, who serves in the Washington office in the Alliance Defending Freedom. I have to say that the Alliance Defending Freedom is first among equals on all the issues of religious liberty and rights of conscience. They are the best friends of Focus on the Family. They are the best friends of the LCMS on these issues, and we have picked the absolute best man to brief us on the two most important cases on the HHS mandate. That's the Health and Human Services mandate. These two cases will be argued sequentially on March 25th. Matt Bowman has had a lot to do with these cases. ADF, in fact, the ADF legal team will be arguing one of those two cases. One is the Hobby Lobby case. One is the Conestoga Woods case, the ADF case. Matt will tell you about those. But here at the very beginning of the year, we wanted to build a bridge between Washington and the rest of the country with regard to religious liberty and rights of conscience as these issues bear upon all Christians and specifically Missouri Synod Lutheran. So, Matt Bowman, it is a real honor and pleasure to welcome you to this first webinar this morning. We really look forward to hearing from you, learning about these two cases and what is at stake. So thank you for joining us.
Thanks for having me here, Tim and Barb, and of course thanks to Bishop Harrison and the Lutheran Church Missouri Synod for hosting me. It's our great pleasure and honor at Alliance Defending Freedom to partner with the Lutheran Church Missouri Synod and to defend their freedom to preach and live the gospel. That's what Alliance Defending Freedom's mission is. We are a pro-life, pro-marriage, pro-religious freedom nonprofit organization that exists to serve the church and to clear the way for the gospel to be able to be preached. And I'm honored to be here to give you a brief overview of this particular battle that has taken us at Alliance Defending Freedom all the way to the U.S. Supreme Court. The fundamental issues here, which involve the Affordable Care Act, also known as Obamacare, present three fundamental attacks on values that we hold dear, and those, very briefly, are whether people of faith, whether Christians, will be allowed by the government to practice their faith in their daily life, to be disciples in their everyday life, first of all. Second, whether the church and her ministries will be allowed to be who they are without the government coming and telling them what they must do and defining really the church's conscience for it. And third is the issue which we very centrally addressed yesterday here with the rest of the pro-life movement at the March for Life in Washington, D.C., and the many marches that are happening around the country, which is whether God's plan for creation and God's image in life can be cherished even just by a community of believers living in the United States of America, or whether they must conform all of their activities to a worldview that disrespects God's plan for life. Believe it or not, all of these issues were triggered and put at risk by the decision of bureaucrats here in Washington implementing Obamacare beginning in 2010 and in 2011. There's a provision in the Affordable Care Act that says that health insurance plans, among the many things that they must do now, they must generally, these plans must cover what the law calls preventive services. These are services to prevent ailments, diseases, problematic health conditions. The law doesn't define exactly what those services will be. It defers that decision to the bureaucratic structure here in Washington, and that structure, driven by an ideological agenda that is hostile to life and creation, decided that among the preventive services that are the most important in their view to be covered must include everything the FDA, the Food and Drug Administration, defines as contraceptives, everything they define as sterilization, and all education and counseling in support of those things. Now, among the items that the FDA includes in its definition of contraceptives include a variety of items that can cause the destruction of a very early human life, in addition or instead of just causing the prevention of that life's formation. And so the government itself admits that many of these items can, for example, the IUD or their morning and week after pills, that many of these items can function after an embryo comes into existence, at that first moment of life, at fertilization, conception, that many of these items, drugs and devices, can function to destroy that embryo either before it implants into the mother's womb 7 to 10 days after fertilization, or in the case of one drug, quite possibly even after that. And so this caused, as if you've been following the news at all, quite a firestorm in the country about who must provide these items in their health insurance plans and to their employees, who must accept them as in their own insurance, despite the fact that they might have either religious or simply moral objections to these items. The long story short, the federal government created a very short list of people who might be exempt from this requirement. At the end of the day, the exemption created for religious objections to providing these items, including abortifacient items, really only included churches and some of their very closely connected integrated auxiliaries. Nonprofit organizations were told that they still had to participate in the scheme to cause these items to be provided, and people of faith who work in their daily life to earn a living, perhaps by running a business, those people were told, you have no religious conscience at all. You can't even begin to claim a religious objection. So these ended up causing various lawsuits. And it's this latter category that became the first set of lawsuits. The people who are families practicing business in their daily life They want to run their business and serve their customers in a way that honors God and that doesn't violate God's commands, particularly with respect to destroying early human life or in their view, devaluing God's plan for procreation. And these people, many families sue. Now, over 40 cases have been brought against the federal government, claiming that religious freedom itself is trampled when the federal government tells people of faith that they must participate in items that even they consider to be abortion, simply as a cost of trying to earn a living and do business as a family. These cases went to court, and overwhelmingly, we at Alliance Defending Freedom and our allies throughout the movement have been winning these cases. Right now, 35 out of 41 of these cases of families in business, 35 out of 41 have led to an injunction, a court order against this mandate for those families. But along the way, courts did disagree about whether families should have this freedom. And in fact, the Obama administration in court took the position that not only is this mandate something that's more important than religious freedom, but that Christians, when they follow the Lord in their daily life, are not actually exercising religion. And if they practice a business, and particularly if they happen to incorporate that business, they have abandoned their religious freedom. And so this led to ultimately two cases that the U.S. Supreme Court decided to grant review on at the end of last year, the case of the Green family that runs Hobby Lobby, and the case of my client, the Hahn family, a Mennonite Christian family from Lancaster County, Pennsylvania, which makes wood cabinets, and which also objected, along with the Greens, to the requirement that they would provide items in their health plan that might cause the destruction of a unique human being. The Supreme Court is going to hear argument on these cases on March 25th, which interestingly many Christians celebrate as being 9 months before Christmas, the conception date of Jesus Christ. On that date, the court will hear arguments, and Alliance Defending Freedom just 2 weeks ago filed our opening brief on behalf of the Hahn family, defending religious freedom for them. In the meantime, while all these cases are going on, the Obama administration created a variety of very difficult to understand rules relating to what nonprofit organizations have to do with respect to this mandate. And the upshot of all those rules was, frankly, to take the issue off the table for the election year of 2012 and delay it a year. That delay has resulted in the fact that at the end of 2013, just a month ago, about 20 different courts issued rulings about whether the mandate of these items must apply also to nonprofit religious organizations, or even in some cases some nonprofit, simply pro-life organizations. And once again, in these cases, overwhelmingly religious freedom has triumphed over the attempt to attack it. In 19 of 20 of those cases, representing organizations such as Christian schools, colleges and universities, Christian educational and outreach ministries. 19 of 20 of those cases have led to a court order against that mandate. But once again, some judges have disagreed and have taken the Obama administration's position on this matter. That position, in the case of religious organizations, has not been so much that these organizations cannot exercise religion. That's what they say about Christians when they're working in their business Monday through Friday. But the position of the administration has been, well, yes, you can exercise religion, but we, the government, get to decide what actually violates your conscience. And we have created a structure whereby through your health plan, all your employees will receive these abortifacient items, but we've rearranged the numbers on the accounting ledger so that you don't have to, so that you can suppose that it's not actually violating your beliefs. And we, the government, get to decide what your conscience means. You should accept that as not being a violation of your conscience. This led to a case that isn't quite at the Supreme Court yet, but it was there on an emergency petition, a case you might have heard of, the Little Sisters of the Poor, the Catholic order of nuns that runs homes for the elderly, and which, along with its Christian insurance provider, Christian Brothers, objected to providing this. We at Alliance Defending Freedom won injunctions on behalf of multiple colleges throughout the country: Geneva College, Biola University, Southern Nazarene University, Mid-America Christian, and 2 other colleges in Oklahoma. And so these cases now are being fought at the Supreme Court, or at the lower court level, and potentially very soon will be at the Supreme Court in a full and complete fashion. Ultimately, the Supreme Court is going to have to rule on the question of, assuming that people of faith in their daily life and Christian ministries are allowed to practice religion, can the government simply declare that these early abortion drugs and contraception and sterilization are more important than religious beliefs? And the fundamental issue, I think, in that decision is going really to be the question of the sanctity of human life and of God's plan for sexuality. Because when the government created this mandate, what it said was that essentially pregnancy is a disease that needs to be prevented. It's such a crisis. Pregnancy as such and early embryos are themselves a threat to health, a threat to our economy, so much so that people's religious objections to participating in attacks on pregnancy or attacks on life those religious objections need to be overridden. And so it's not enough for this government and our past Supreme Court rulings to declare that items such as abortion will be legal, but now everybody has to participate at some level because the government says so. That's ultimately going to be the issue of whether what the Supreme Court has created so-called right to abortion and the like will now be not just a right but a requirement that everyone has to fund, facilitate, and that'll be and whether that is abortion can be so radicalized that it violates even our first freedom of religious freedom, cherished in the First Amendment, codified in federal statute, given supposedly the highest protection of law that is available in our legal system, something that our current federal administration is denying. And so Alliance Defending Freedom is fighting these battles all along the way, representing many different families in business, representing the Hans at the Supreme Court this month and in March, representing many nonprofit organizations and giving guidance to many other organizations that might not now be subject to the mandate but might be in the future. We're honored to be doing that, and we're glad to be here to answer any questions that you have about that dispute.
Matt, thank you. That was absolutely terrific. And by the way, you're the first person that I've heard say, and perhaps for many of the people who are joining us on the webinar this morning, that March 25th is in fact the Feast of the Annunciation. This is something more than a coincidence. I'd like to ask you 2 questions just off the top that I think will benefit the people who are not in Washington but very interested in everything that you've said. And both of my questions are programmatic. The first question is the 25th of March. Can you give us a brief capsule? What actually happens on the 25th of March? I mean, in other words, if all of us who are on the webinar could actually be in the Supreme Court that day, what actually happens? How long are the cases argued, et cetera? And then secondly, very importantly, after those cases are argued on the 25th, how long do people have to wait until we find out what the Supreme Court actually decides?
Sure. The Supreme Court hears about 100 cases a year, and I was just at 2 of them in the past 2 months. The Alliance Defending Freedom was there representing the ability of town councils to open meetings with prayer. And then we helped fund a case just a week or 2 ago representing the freedom of speech of pro-life advocates to offer alternatives to women. And what happens at a Supreme Court hearing is something that actually all the callers could theoretically come to. It's a public hearing. You can wait in line to get a ticket and go in at 10 a.m. On the morning of a Supreme Court hearing. After all the people are seated who are going to be watching argument at 1 First Street here in Washington, D.C., the 9 justices come out to the introduction, God Save the United States and this honorable court. And they will hear argument for essentially 1 hour, typically on standard cases. They'll hear argument for an hour. There'll be an opening argument by the person who is appealing. The respondent, sometimes this is the government, sometimes it is to dispute between private parties, will respond. And then typically the person who opens will have saved themselves 5 minutes to rebut that argument. After that, everyone is, there might be a second case, but everyone is dismissed, and then the justices go back to their chambers. They will privately vote on which way the case should go. They will assign one of the justices to write the majority opinion. If there's a dissent, they'll assign the dissenting opinion, and then they'll go ahead and write it and issue that opinion probably, in this case, in June. Your second question again?
Yes, I wanted to remind people, I'll ask you in just a moment, Matt, but I wanted to remind people that in the lower left-hand part of their screen, there's a place where people can type questions, either of you or of myself on these topics. We would love to hear from people and know what their question is or their thoughts about what's been said. The second question that I was asking, in addition to what will actually happen that day and when the decision will take place, the other thing I think that would be helpful for people to know is the deliberation. I'm told that after cases are heard in the court, that in fact a conference of the Supreme Court meets very soon afterwards. So although we have to wait as Americans until May or June for these decisions, that in fact the court, members of the court, begin discussing among themselves the cases very quickly afterward. I wonder if you might shed some light on that process.
That's right, and in fact they're already thinking about the case, and this is at minimum in a very important way, something for our participants here to take to prayer, because the justices come into an oral argument 90 days previous. The parties in the case have already filed their written brief of the case. That's what I did on January 10th for the Hahn family, and it's what the government did in opposition to Hobby Lobby. And so the justices are reading the briefs. They're forming their view of the case right now. And then when the argument comes, they're hearing the arguments, maybe getting some of their questions answered, but then they take it to a vote maybe that day or maybe another day that week. They assign who's going to write. And then as the justices write the opinion, sometimes they change their minds. And so really all throughout the process, until once the briefing begins, until the opinion is issued, the justices and their assistants, their legal assistants and their law clerks, are forming their views about how this case should go. And in this case, it'll be their views about the importance of religious freedom.
Maggie Carner has a question. She asks, how does the Hobby Lobby and the Conestoga cases differ? That's an excellent question, Maggie. Thank you. Matt, for all the similarities that underline these two cases, how do they differ?
They don't differ very much. Really, there are different kinds of companies. The Hobby Lobby, of course, is an arts and crafts chain store. Conestoga Wood Specialties makes wood kitchen cabinets, and they don't retail them. And they're different sizes. What I think really is the significance of both of these cases being there is that people of faith practice their faith in their daily life in a variety of contexts. Some of them do so in a national chain store. Some of them do so as a Mennonite family that makes wood cabinets. Some of them do so in very small family businesses and companies. And the government is attempting to essentially take religion out of the sphere of daily life, declare that religion has no place in business or health care or in a previous case that the government lost attempting to claim religion has no priority in education. Declaring these areas of human life where our discipleship to the Lord is lived out, declaring these areas to be quote-unquote secular, areas where the federal government, instead of the Lord, will be the ruler and will reign and set the decisions there. And so by taking both of these cases, I think the Supreme Court has given us an opportunity to show that, in fact, people of faith practice their faith in a variety of different contexts.
I'm very glad that Maggie asked this question because far beyond the confines of Christianity in America, Matt, as you well know, probably better than anybody, one of the questions that comes up very often is, shouldn't we just have a carve-out for churches or auxiliaries or paraministries? In other words, people will argue and are arguing as we speak that if you're a company, if you're a corporation, if you're a nonprofit that doesn't necessarily have a quote-unquote religious mission, shouldn't they be compelled by the sort of government diktat or mandate? In other words, isn't it a central view that our conscience as Christians and our religious liberty as Christians, it's not confined to the four walls of any geographical space or place, that in fact we are Christians if we are founding businesses, we're Christians if we are plumbers or carpenters or working in paraministries or whatever. I mean, this would seem to be a very central part of the argument of these two cases.
I think that's exactly right, Tim. And I'm no theologian, but it seems to me that, as you said, the essence of Christianity and many other world religions is that it doesn't just happen on your day of worship. Or if you're not following the Lord throughout your life, then you're not really doing what you're not really living a life of faith. And really, the issue here, I think, is twofold. First of all, the attempt to say, well, really, we should only have religious exemptions for the church itself, it misunderstands what the church is. The church is the people of God. The church isn't just the clergy. It certainly is them, but it is the church is the community, the entire community of believers, and it's an attempt by the government to say, well, really, the church isn't those who live their faith in life. But I think also the attempt to simply declare that only the institutional church has religious freedom is also ultimately self-defeating, because, of course, the church itself, its job is to preach the gospel. And if you were to only protect the church in preaching the gospel, but then you were to allow the government to prohibit the congregation from practicing the gospel, then you really haven't protected the ability to preach the gospel in the first place, because what good is the ability to preach if the people who are listening to you don't have the freedom to hear and follow the Lord?
Adrian Hines from Higginsville, Missouri, asked another excellent question. She says, it can be easy for us to keep these cases at a distance, hoping that people like the ADF staff will be able to take care of the situation for us. She asks, but how can an average LCMS member sitting in the pew still support the work of defending religious freedom, even if we're not in Washington, D.C.? I mean, this is really, Matt, a very insightful view. It's not just that the Supreme Court is here in Washington having sort of a theoretical, discussion. This goes to the very heart of our religious liberty, and the question has to be, applied, faith in action. How does this directly impact the average Lutheran in America, whether you live inside the Beltway or, as far away as possible? What is the real world application? What does this actually mean for real Lutheran Christians?
Well, I think the way for Christians to get involved is, first of all, to pray, to pray for these cases, to pray that for the Supreme Court justices. But secondly, it is to live your faith. It is to follow the Lord in your daily life and look through your life about how your discipleship will impact what you're doing, including at work. And that's what the Hahn family and the Green family were doing when all of a sudden the federal government came in and told them that they had to start violating their faith. They were practicing their faith in their daily life. They were trying to live as disciples Monday through Friday, and that's what we all should do. Specifically with regard to these cases, of course, people can learn more about our involvement by going to alliancedefendingfreedom.org, and we do represent our clients for free. We've come alongside the Hahn family and said, we're a nonprofit organization. We exist to defend religious freedom. We'll represent you and religious colleges and other ministries and Christians throughout a lot of business contexts for free. We can only do that with the prayer and support of people like the Christians who are listening to this call.
Barb below instructs me, and I'm so glad that she did. We know that we have people who are joining us, and we are very eager to open up our telephone line for questions as well. Even if there's a little background noise, that doesn't matter in the least bit. But if you are joining us by phone and not by web, we would love to hear from you. And if there are people there who would like to ask a question, I'm very happy, please, to open up the phone line. And any question that you'd like to ask me or Matt, we would love to hear from you. And since this is our first webinar, let me just pause for a moment. I know there is...
All attendees are muted and may unmute themselves by pressing *6.
There you are. So we got the wonderful instruction. You can unmute yourself by hitting *6. And if you are on the phone joining us and would like to ask a question of Matt or myself, we would love to hear from you. I think the phones are now unmuted. I'm going to pause for a moment to see if there's anyone on the line who would like to ask a question. And please don't be shy. Anybody on the line who would like to ask a question? We have a follow-up question from Maggie. She said, if the Little Sisters of the Poor case ends up in defeat, what kind of impact should the church expect, in particular the LCMS? And Matt, that's another important question.
Well, even if the Little Sisters of the Poor case were to temporarily end up losing their bid for an injunction, 18 other nonprofit organizations, including the Guidestone Baptist church plan that offers insurance, along with many of their ministries, have won injunctions. And so we're still going to have an overwhelming majority of courts that have granted injunctive relief, including in situations positionally identical to the Little Sisters. And therefore, those will be victories that we will continue to build on, and then at minimum take up to the Supreme Court because the courts disagree. And that's ultimately how the Conestoga and Hobby Lobby cases got to the Supreme Court. It's because we had won all these cases at the district courts. We had won 3 cases at the U.S. Courts of Appeals. We lost 2. And because of that disagreement, the Supreme Court took the case. So that's where we are headed, that even if there's a temporary defeat in one of these cases, we've been blessed with so much success that we can at minimum take that back up to the U.S. Supreme Court.
Actually, I want to build on that because our next question is from Dorothy at Kranz, who says, if the Supreme Court votes against these organizations, how do we as people of faith continue to stand up for our religious rights of freedom? That's a perfect piggyback to the point you just made. I mean, what is the next step? We all are praying for victory and for success in the Supreme Court, but Dorothy makes a good point, Matt. We've all as Christians been disappointed many times. We know that our hope is not in the Supreme Court ultimately, but we are citizens both of the United States and ultimately of heaven. But this side of eternity, what do we do if we are handed a couple of defeats?
Well, ultimately, of course, there is no defeat in Christ, and so the ultimate answer to that question is we follow the Lord, and what comes is in His hands. In the short term, though, we continue to use. We have a legal system in America that gives us the ability to seek legal protection for our ability to follow God, to cherish life and marriage, and we continue in that battle. And that's what Alliance Defending Freedom is doing. And what we're finding, despite setbacks, obvious setbacks along the way, that we win at Alliance Defending Freedom almost 80% of our cases litigated to conclusion, and that these battles for life and marriage and religious freedom can be won. And what we've found is that when we show up to that battle, not only in these cases, but in training up young lawyers and training law students, as we do at Alliance Defending Freedom, with 150 of the best law students in the country coming to our Christian training summer program. When we train up lawyers and law students, when we infuse the culture of our system with the Christian worldview, that we can have short and long-term change, cultural change in this country, and I really believe that we have a vast future ahead of us of success and of seeing the Lord honored in our country.
Yes, and may I say I've had the privilege of joining the Blackstone Academy with the ADF a number of times, and you mentioned the ADF website earlier. It's one of the absolute best programs of training up young Christian lawyers. It's a remarkable program. I also wanted to mention, as we keep our phone lines open and continue to encourage people who are joining us, if you have a question, to go ahead to the bottom left of your screen and type a question if you have it. Or as I say, the phone lines are open. If you'd like to ask, we welcome your joining us either way. I wanted to mention two things in the course of what's been said. One is the Free to Be Faithful portion of the LCMS website is really terrific. There's a remarkable amount of information there, much of it regarding the issues that we've spoken about today. And as Matt Bowman from ADF has said, another great resource is the Alliance Defending Freedom site. We very strongly, heartily recommend that for those who are joining, those are two really terrific places to go for excellent information. And we at Focus on the Family really rely on them. Let me say as well, just one logistical question, which is if you have just joined us, we are having our first webinar. We're talking about the Religious Freedom and the Affordable Care Act, its impact on the two Supreme Court cases, which will be argued March 25th. Matt Bowman is with the Alliance Defending Freedom here in Washington, and I am Tim Gaeglein, also here in Washington, with Focus on the Family. And I want to go to another question, if I may, Matt. It comes from Amy. She asks, what do you see as the next big battle for us on the life front, in light of the March for Life from yesterday, where Focus on the Family was a very significant participant? It's very timely and very relevant. I know that Maggie Carner and the incredible Lutherans for Life and many other Lutherans were joining in that march as well. We're really eager to ask you, Matt, what is the next big battle? This is a great question.
Well, I'm blessed to serve within ADF on the life teams, focusing specifically on life issues, and I think the life battle is very exciting. The pro-life movement is very vast. It goes far beyond the legal realm, and so I don't want to say that the legal activities are the most important, but several battles that are going on around the country.
We're actually having a bit of problem. We see you just fine, but we're not hearing you fine. And I'm wondering if you might try. This is the world of technology. It's not a problem, but I'm wondering if you might try to readjust your audio just to see if we might hear you a bit more clearly.
Okay. Is this any better?
Can you do a quick test? Sorry.
Hello?
Yes, we're hearing you better. Yes,
okay.
Go ahead.
All right. I'm honored to be on the life team within Alliance Defending Freedom, and the life battle goes far beyond the law. But to hit a few of the exciting things that I think are happening within the legal realm, what's happening is that despite gridlock here in Washington, D.C., states around the country are passing pro-life laws that are closing down abortion facilities. Last year, almost 90 abortion facilities around the country closed, largely because of pro-life laws that were passed. And when these laws go to court, Alliance Defending Freedom comes alongside the state governments to defend those laws to protect women from the harms of abortion. The second thing that's happening that I think is very exciting is the continued expansion of pro-life pregnancy center outreach, which really is the church in action on abortion to come alongside women to offer them the mercy of Jesus Christ and to offer them the practical help to be able to choose life. And that outreach is under attack from the abortion industry, but I think is overcoming that. We at Alliance Defending Freedom are working to protect in court the rights of pro-life pregnancy centers to be able to minister to women without pro-abortion local governments telling them and trying to shut them out of business, telling them what to do. Thirdly, I think is the development of a combination of the youth movement in the pro-life movement and their use of social media and multimedia. There are a lot of really powerful and moving messages, videos, and outreach to young people that is causing the beliefs of young people in our country across the board to be more pro-life than they ever have been. And here at the March for Life yesterday, we were blessed to be able to see many of these efforts and outreaches. For one example is Students for Life of America, which is an organization that Alliance Defending Freedom comes alongside to defend their right to speak the pro-life message on college campuses and on high school campuses. And Students for Life of America is expanding in a vast and powerful way, opening new campuses or to groups on college campuses. And there are so many other organizations that are out there on Facebook and Twitter and are really changing hearts and minds on the dignity of human life.
Let me ask you in that regard, Nabil Nauer from Ardmore, South Dakota asks, any possibility in your view that Roe against Wade might be reversed?
Yeah, of course. I think that Roe versus Wade, many people have criticized it legally, and really no one recognizes it as a legitimate legal position. I think that the way that Roe versus Wade is going to be reversed is going to be a combination of these legal efforts in the states that are restricting abortion in order to protect women's health and the health of children, the lives of children, alongside so that the passage of those laws, which will then end up in court, where we at Alliance Defending Freedom and can come alongside states to make the best arguments on behalf of life, and so the Supreme Court will have to confront this issue again. But that, alongside the broader cultural change, the church offering its heart and its help to women and young people, realizing that we as a country don't need to offer abortion. We can offer life-affirming choices. I think both of these need to be happening at the same time, and in the convergence of both of them, God can work to reverse this outrage. And I think as it took decades to reverse the institution of slavery in America, we can't predict exactly when it's going to happen, but I think it is definitely going to happen. And I think we're seeing progress towards that every year.
Thank you so much, Matt. I want to ask one more time if there's anybody who has joined us by telephone. If anyone has a question, we would love to hear from you. I know the phone lines are open. Okay. And we have gone through our entire number of chat questions, so that's excellent. And we're also still within our time frame, so we're doing well. I wanted to mention, if I may, just some things in closing. The first is the Free to Be Faithful part of the LCMS website. I'm very eager to direct anybody who's looking for more information on the panoply of religious liberty and rights of conscience issues so is the Alliance Defending Freedom and the Focus on the Family website. So please, we encourage you to go there for any other information you would like. And to summarize very quickly what Matt Bowman has shared with us, the two Supreme Court cases will be argued here in Washington in front of the Supreme Court sequentially on the 25th of March. And as Matt has said, we do not expect a decision much before June. It could come before then, but that June is the probable time. I also wanted to mention that the president of the Lutheran Church Missouri Synod, Matthew Harrison, who has been such a strength and encourager of work of the LCMS in the public square, could not join us today, but he has really been the font and the dynamism behind webinars of this kind, and we are very grateful to him. And I wanted to acknowledge, if I may, many of the people who work so closely on the LCMS role in the public square, especially Barbara Lowe, who I mentioned earlier, and who you met by the webinar, Maggie Carner, Adrian Hines, Ann Stillman, who has done such phenomenal legal work for the Missouri Synod, Dorothy Kranz, and others. And from a personal standpoint, I wish to thank Ashley Brannon, our administration manager of Focus on the Family, who has been so incredibly helpful to me in working this. One last item, if I may, while we have Matt Bowman. We will be having the next Free to Be Faithful webinar. It is now scheduled for Thursday, March 13th. Again, Thursday, March 13th, as we get closer to those Supreme Court cases, we will really welcome everybody back to join us, and we would love to expand the number of people joining us. This has been just an absolutely terrific near hour, and we're appreciative. Matt Bowman, anything that you would like to say in conclusion on our webinar, anything that you would like to finally share with people who have been good enough to give us some of their time this morning?
Just want to thank everyone for coming. Again, let people know AllianceDefendingFreedom.org is a resource for them. And we are a resource for all of you, so please let us know if there's anything we can help in your life and your ministry.